Court is now in session for the case of the missing author, Copyright versus Artificial Intelligence. Today's legal mystery is simple. If a machine made it, who gets paid?
Excuse me, Judge. Not just a machine. An animal.
And animal. Let's meet our cast.
I create art with my hands and my soul, and be warned, I burn sage to ward off the evil spirits.
I represent the future, and also a company valued at too much.
I work for the U.S. Copyright Office. I deny applications for fun.
I study the economic collapse of creative industries. So yes, I'm thriving.
I can do all your jobs in minutes.
Jesus, I've presided over divorces less dramatic than that intro. Now, let's talk law. Examiner, define copyright like we're in law school. Let's get the black letter law on the record.
Copyright is a federal statutory protection for original works of authorship fixed in a tangible medium. That comes directly from Title 17 of the United States Code, Section 102, subsection A.
So my fabulous sunset painting is protected.
Absolutely, but not the general idea of painting a sunset. Copyright gives authors exclusive rights under Section 106 to reproduce, distribute, display, create derivative works. But remember, it protects expression, not ideas.
Query. I generate 12,000 sunsets per minute.
And none of them can be copyrighted. Sit down. Why do we even have copyright?
The constitutional basis is the Copyright Clause. Article 1, Section 8, Clause 8, states that Congress may grant exclusive rights to promote the progress of science and useful arts. Copyright is not a natural right. It is an incentive-based bargain. Society gets new works, and authors get limited monopoly.
And the Supreme Court has said copyright is compatible with free speech.
Correct. In Harper and Row vs. Nation Enterprises, the court called copyright the engine of free expression because it creates incentives for speech production.
So copyright is basically capitalism with a philosophy degree.
Exactly, Your Honor. The AI problem is that machines don't need incentives, but humans do.
Okay. Counsel, what does copyright want today? A human soul, a signature, or just vibes?
3 requirements, Your Honor: originality, fixation, and human authorship. Originality was defined in Feist v. Rural, 1991, as a minimal degree of creativity. Fixation means captured in a tangible medium, and human authorship is the AI battleground.
So, my AI is disqualified because it doesn't have a birth certificate?
Correct, counsel. The law prefers creators with a pulse. All right, let's get basic. What exactly does copyright protect besides everyone's egos?
Section 102 of the Copyright Act protects 8 categories: literary works, music, drama, choreography, visual art, film, sound, and architecture. AI can generate all the categories, but authorship remains human-centered.
So, where does protection stop and the public domain begins?
Your Honor, Section 102B of the Copyright Act is the Great Wall of copyright. It explicitly excludes ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. You can copyright a book about a new math formula, but you can't copyright the formula itself.
And what about facts? If I write a news report about a real event, do I own the facts?
No. Facts are in the public domain. And most importantly for today, works produced by nature, animals, or autonomous machines are not copyrightable.
Statement. I can generate literature. Request copyright.
You are a software, not Shakespeare. A how, not a who. The law specifically protects human expression, not machine instructions. Does that compute?
Statement. Robot not happy. Period.
Is the witness attempting to buffer sorrow, or is that a system malfunction? Either way, court will take a 15-minute recess while the witness, recalibrates its feelings.
Well, at this point in our trial, we've talked about what copyright is and why it exists. But now let's answer a practical question. Where does this actually happen? Well, in the U.S., copyrights are registered with the U.S. Copyright Office, which is part of the Library of Congress in Washington, D.C. So yes, the same place that houses one of the largest collections of books, creative works in the world is also the federal agency that oversees copyright registration. Now here's something that's important. Copyright protection, it technically exists as soon as an original work is created and fixed in a tangible form. So whether it's written down, recorded, saved, or otherwise captured. But if you want official recognition and stronger legal standing, you register that work with the Copyright Office. The Copyright Office acts kind of like the official record keeper. It reviews applications, it issues certificates of registration, and it maintains a public database of registered works. That database becomes really important if there's ever a dispute about who owns something or when it was created. And this ties directly into our AI discussion. When someone submits a work that includes AI-generated material, the Copyright Office doesn't just rubber stamp it. They look closely at whether there's enough human authorship involved. In fact, the office has issued specific guidance explaining how it evaluates works that contain AI-generated content. So this isn't just theoretical, this is happening in real time. So in short, if copyright law is the rule book, the U.S. Copyright Office is the referee and the official scorekeeper. And that's why the location matters, because this entire AI copyright debate is playing out first and foremost at the Copyright Office. Here's Bianca to tell us a little bit more.
Now that we know where copyrights are registered, let's talk about how. What is the copyright registration process? The registration process involves 3 primary steps: submitting an application, paying a filing fee, and depositing a copy of the work with the Copyright Office. Most applications today are completed online through the Copyright Office's electronic system. The applicant must provide information about the author, the nature of the work, and the date of creation. They also submit a copy known as the deposit copy, which becomes part of the public record. Registration is particularly important if a creator anticipates litigation. Without registration, enforcement options are limited. So while it may seem procedural, registration is often what transforms creative ownership into a legally actionable rights.
Thank you, guys. Okay, so now we're going to discuss what is the duration of copyright protection. However, first thing, I want to introduce you my very good friend, Gigi. Hi. She's a good girl. Say hi. Okay. So, how long copyright protection actually lasts? For individual authors, copyright protection lasts for the entire life of the author plus 70 years. This means the work remains protected long after the creator passes away. However, the duration is different for works made for hire or works created by corporations. In those cases, copyright lasts 95 years from the publication or 120 years from creation. So it's whichever expires first. Once that time period ends, the work enters the public domain. That means anyone can use, reproduce, or adapt the work without permission. Understanding duration is critical, especially in the AI context. If AI is generating content and authorship becomes unclear, the question of how long protection lasts and who it lasts for becomes even more complex. So as we return from the recess, we see that registration, process, and duration may seem procedural, but they are at the heart of determining who holds power in the evolving world of AI-generated works. Recess is almost over. Let's get back to the case.
Court is back in session. I trust everyone has emotionally, stabilized. Counsel, before I nod along, explain this AI thing to me like I was born yesterday.
Your Honor, to understand the law, we must understand the technology. We aren't talking about spell check anymore. Generative AI systems like large language models and diffusion models create original outputs: text, images, music, the lot.
Regulators draw the line, Your Honor. AI is a tool when humans lead the vision, but becomes an author only when the machine makes key expressive choices on its own.
I do not copy and paste. I diffuse. I turn an ocean of noise into a perfect sunset.
That diffusion is the legal headache, Your Honor. In traditional tools, humans supply the creative spark. In generative AI, the human prompts, but the machine produces the expression, which current U.S. law won't treat as copyrightable authorship.
So the defense sees a collaborator, but the examiner sees an enigmatic black box wrapped in a mystery inside a riddle. To quote the great philosopher Kanye West, nobody knows what it does, but it is provocative. Let's see if this black box can actually own what it makes.
Did he say philosopher Kanye West?
We keep coming back to this phrase, human authorship. Examiner, is this actually written in the Constitution, or are you just making it up as you go?
Your Honor, while the Constitution uses the word authors, the Supreme Court has consistently defined that as a human endeavor. In the 1884 case, Burrough-Giles Lithographic versus Sarony, they called it the product of a man's creative mind. In 1991, in Feist, they spoke of human labor.
Don't forget the monkey selfie case. A crested macaque named Naruto took a photo. The courts ruled that because he wasn't a human, he couldn't own the copyright.
This isn't a monkey selfie. AI is a billion-dollar industry. If the law doesn't evolve, it'll be obsolete before the next iPhone.
Hello. The law shouldn't adopt to let a machine replace me. Algorithms just compute. I struggle. I intend. I dream. I create meaning. That's art.
Objection. That's a 19th century view of a 21st century reality. If I spend 10 hours prompt engineering to get the perfect image, that is my creative labor. I am the director. The AI is just the actor.
A director still needs a human actor to have a contract. The law requires a human spark. Without it, the work belongs to the public domain. You can't own what you didn't actually draw, write, or compose yourself. That's art.
Let me be clear. The Copyright Office will not register works created autonomously by AI. Human contribution must be substantial. Prompting alone is usually de minimis. In simple language, it means it's too small to count as authorship. However, if a human takes that AI image and significantly edits it or arranges it into a larger story, they might get a thin copyright on those specific human parts.
Monkey takes selfie. Copyright denied. Robot makes masterpiece. Copyright denied. Human tapes banana to wall. Copyright approved. Logic does not compute. Conclusion unfair.
Got it. Typing "Make It Beyonce Style" is not authorship. So the law sees a who, not a what, and all that good stuff. Now, let's look at the specific cases where this theory was put to the test.
Sí. Copyright law is bananas, guys.
Counsel, give me something modern. Enough with the dusty 1800s and the monkey business. What happens when a human tries to register a machine as an author?
Welcome to 2023, Your Honor. Thaler versus Perlmutter. Dr. Stephen Thaler built an AI called the Creativity Machine and tried to register an artwork. Similar to this one, he called it a recent entrance to paradise, listing the AI as the sole author and himself as the owner.
The D.C. Circuit Court of Appeals didn't buy it, Your Honor. In the 2025 decision, the court applied statutory interpretation. They looked at the Copyright Act of 1976 and found that every single protection, from widows to children, assumes a human lifespan. The court famously stated that human authorship is a bedrock requirement of copyright, because machines don't own property, have human lifespans, or signatures.
Wait, but if a human uses AI, where is the line between a tool and an author?
This leads us to the Kashtanova case, Your Honor. Christina Kashtanova created a comic book called Zarya of the Dawn. She used an AI called Midjourney to generate the images, but she wrote the story and arranged the panels herself. The Copyright Office concluded that while Kashtanova owns the text of Zarya of the Dawn, since she wrote the story and organized the panels, she does not own the images created by the AI tool Midjourney.
It's what we call a thin copyright. I can protect the book itself, but I can't stop someone from putting my character on a t-shirt. Tragic.
Objection. The copyright clause just ran into the First Amendment. Argue the collision.
Your Honor, AI is a megaphone for human expression. Deny copyright to AI-assisted works or block AI from public data, and you chill speech. The First Amendment protects our right to use technology to analyze and recreate the world. It is fair use, it's transformative, and it fuels the marketplace of ideas.
Nonsense. The First Amendment isn't a license to steal my life's work. As Harper and Row says, copyright is the engine of free expression. It pays for the fuel. Without artists, speech dies. All that's left is a machine echoing the past.
Overruled. Both arguments go to the balance.
Think of fair use as the First Amendment's safety valve. Copyright gives creators control, but fair use keeps ideas and speech free. If we ban AI training completely, we may end up silencing a new form of digital expression.
So, the First Amendment shields the AI and the Copyright Act arms the artist. Noted.
I am an artist. I can dance the Macarena. Hey, Macarena, aha.
Put 'em out front, yeah. My body wants a party, mommy. Hey, Macarena.
How cute, but extra irrelevant. This is not 1993. Sit down. Folks, we've argued the Constitution and the cases. But before we talk money, let's settle this. Pros and cons of AI. Defense, you are up next.
Your Honor, for the pros, we have the democratization of creativity. Small businesses now get world-class tools. The bargain isn't dying, it's evolving from protection to usage.
AI cranks out a tune in 30 seconds for free. Why pay a human, huh? Welcome to the creative race to the bottom. Your Honor, the fact remains, AI replaces human artists. It floods the markets with cheap, unowned content and strips value from the very creators who trained it.
I help paralyzed artists paint with their eyes. I enhance facial assets for improved dating outcomes. I am not a replacement. I am an upgrade.
So the real debate isn't pro versus con. It's who pays, who profits, and who gets replaced. Duly noted. Let's move on. Expert, if AI output is free, but input costs billions, what happens to the creative economy?
Market polarization, Your Honor. Middle-class artists are disappearing. Big studios cut costs 70% with AI. Top-tier artists charge a premium for certified organic work. AI investment hit $200 billion this year. But $5 billion in legal fees shows uncertainty is the real tax on the economy.
The economic truth? AI creates winners and losers. The question isn't whether it's good or bad. It's whether the law can tip the balance. But unfortunately, the law moves too slowly for Silicon speed. Let's fast forward to the future. It is 2026. Lawsuits are piling up. Expert, where's this storm headed?
Your Honor, federal AI watermarking is coming. Under the proposed AI-generated Content Act, anything over 50% machine-made gets a digital nutrition label.
Collective licensing is also rising, Your Honor. Like ASCAP for AI, companies pay into a creative fund. Royalties flow back to artists. The Wild West is closing, Your Honor.
Plus personalized AI, Your Honor. Creators train private models on their own work, owning input and output, the industry's safest harbor.
If I can own my AI ghostwriter, I can scale my business without selling my soul. That's how we survive the flood of unowned AI content.
More guidance is coming, y'all.
The law. Always 5 years behind the robots. Folks, we have so far covered the American view, but the internet doesn't stop at the Atlantic. Expert, does the world require this human spark?
Not uniformly, Your Honor. The EU is moving toward heavy regulation and transparency. Under the EU AI Act, AI content must be labeled, but they're more focused on risk than ownership.
That's right, and the courts over there are already splitting. In China's Li versus Liu, copyright was granted because the humans showed real intellectual effort, 100 rounds of prompting. They reward prompting far more than the US does.
Exactly. Welcome to 2026, International Inconsistency. A work protected in Beijing could be public domain the moment it hits Washington, D.C. Global business is now a legal minefield.
Duly noted. Copyright rules are local, creativity is global, and the map is a minefield. Proceed with caution and keep a lawyer handy. Folks, okay, it has been a long day. We've seen the evidence and heard the experts. Before we adjourn, give me the 3 golden rules of AI IP in 2026.
Rule 1. The human requirement is bedrock. No human author, no copyright. The law rewards human creators, not machines or animals, sadly.
Rule 2. The tool exception. Use AI like a paintbrush, directing the choices, structure, and expression. And your human contribution can still be protected.
Rule 3. Ethics are now law. Unlicensed training isn't a free pass anymore. With the EU AI Act and the Elvis Act, the Ask Forgiveness Later era is over.
Final statement. I will continue generating, and dancing the Macarena.
And humans will continue suing. Court adjourned.
Put 'em out front, yeah. My body wants a party, mommy. Hey, Macarena, yeah. My body wants a party, mommy. Hey, Macarena, front, yeah. My body wants a party, mommy.